SwayamPrabha. Digital India. Educated India.
So, welcome back to the course of Law of Torts, Consumer Protection and Motor Vehicles. Today we are in the 10th lecture, and in this lecture we will discuss the concepts of contributory negligence and nuisance. Now, in my previous lecture I have discussed negligence in details, and an action for negligence can lie, what are its constituent elements, some case examples where how negligence has been determined, and also the revolutionary rule of existence of duty of care as upheld by the courts in 1931 Dono versus Stevenson judgment. So, after that, one element of negligence is still left, which is, you can say, a rule or even used as a defense. When I discussed the general defenses, I have mentioned that these are defenses which are available to all types of torts, but with reference to specific torts, some specific defenses are also allowed. Now, with negligence, there is a very specific defense which is called the defense of contributory negligence or rule of contributory negligence. So, today we will start our lecture with the discussion on rule of contributory negligence. So, the topics that will be covered in this lecture are following: rule of contributory negligence and its application, what amounts to nuisance. So, after completing contributory negligence, we will move into the domain of nuisance, which is another category of torts. So, from negligence to nuisance. Now, negligence, nuisance and trespass are very closely related in terms of how they are conducted, and we have also seen in many cases in the past discussions on strict liability or even in negligence that parallelly claim of trespass or nuisance has also been raised. So, concepts of negligence, nuisance and trespass, even strict liability, may lie in closed domain because they are against property, they are against person. So, therefore, there is a possibility of more than one overlapping at times. However, they have their marked domains. So, that is why I am teaching these concepts in a same parallel manner, so that you can understand the distinctions between each one of them very clearly. So, after contributory negligence discussion, we will move to nuisance, and nuisance are of generally two categories: private and public nuisance. We will discuss the aspects of public and private nuisance with case applications, and one case which has been historically given a very important significance in the Indian jurisprudence, decided in 80s, Verichand versus Ratlam Municipal Corporation by the Supreme Court, and it is also regarded as the kind of first environmental law judgment in India. But in this case it was largely related to tort of public nuisance, which was remedied through the court by using section 133 of the Code of Criminal Procedure, where magistrate has a power to deal with or removal of any kind of nuisance which is public in nature. So, how it applies, and then finally we will discuss the remedies in nuisance. So, we start with contributory negligence. So, what is contributory negligence? Let me give you a small pictorial representation. This is a road which turns here and continues, and on both sides of the road there are buildings where people are staying. So there are buildings where people are staying, and there is no precise speed limit prescribed for the road, but it is presumed when it's a busy residential area road, no vehicle is supposed to generally drive beyond 20 to 30 kilometer speed, more than 30 kilometer speed. So usually 20 to 30 kilometer is the speed limit. Now one vehicle which is approaching from this side drives at a speed of 50 kilometer, and almost at this intersection very close hits a, so the spot where the accident is happened is marked with X, hits a pedestrian. Now the pedestrian brings a suit for negligence and for damages that has been incurred because of the injury caused due to the accident. And one of the theories that has been established with reference to proving negligence is that the person was driving at a speed which is over the normal speed limit, or a reasonable prudent man, whatever speed limit he will usually apply, he was driving more than that. Of course, two defenses are now pleaded by the defendant. One is that it was relatively not so busy road at that point of time of the day. So it was afternoon, where usually most of the people do not stray on the road. So shops are closed. So it's not a market area; it's a reasonably residential area. So around afternoon time, late afternoon time, usually the road is empty or much less crowded. Very few people are there on the road. So this was that point of the time of the day. So driving at 50 kilometer was not something very unnatural or a reckless aspect, but it was definitely a overspeed. But so that was the first argument that was made by the defendant. The second argument made by the defendant was that he could see the pedestrian some 100 yards before. So actually when he saw the pedestrian, he saw him around this point, and from this point he started giving honk. So he honked quite loud and clear, but the pedestrian did not move. He was walking at his own speed in the middle of the road. And the second very important aspect is the pedestrian had in his ears earphones, and where he was playing music at a very loud voice. So therefore he was unable to hear the honk of the car. And so the pedestrian, if he was not using the earphone, he could have probably heard the honk and had sufficient time to move. And then the question comes that the pedestrian has also now contributed in terms of his negligence, because wearing a earphone and walking in the middle of a road is not a permissible factor. So now what happens is that the plaintiff is, the defendant is also negligent in some aspect, because he is driving at a speed of 50 kilometer, and after seeing even almost like 50 to 60 yards before, he could not avoid the accident. So that means there was definitely some negligent driving on his part. And also the pedestrian, who is a plaintiff, also has contributed because he was using a earphone, which is normally not supposed to use when it comes to walking on the road. This is what is called the classic case of contributory negligence. Now here, this pedestrian's negligence is pleaded as a defense by the defendant. And that's what is contributory negligence, that he contributed also by his negligence in the happening of the event. It was not solely the negligence of the defendant. The pedestrian or the plaintiff in this case has also contributed by using earphone at the time when he was walking in the middle of a road. So contributory negligence therefore means that the deceased or the plaintiff failed to take reasonable care of his own safety, which was a material contributory factor to his death or injury. And it is also used as a defense pleaded by the defendant. So, it is a rule which is used usually by the defendant, and it is pleaded in action of negligence. If the plea is successful, the plaintiff may lose the action even with the slightest negligence. And that is where the problem with contributory negligence rule used to lie earlier. So, even if with the slightest of negligence on the part of plaintiff, if we could prove that there was, if the defendant could prove there was a negligence on the part of the plaintiff which contributed into the factor of his death or injury, then with the slightest of negligence also that plaintiff will lose his action in negligence. The reference of this is this case of Butterfield versus Forrester, 1809. In this case, the plaintiff was riding his horse, violently collided against the pole and got injured. The pole was erected by the defendant for some repair work of his house. On the road, there was sufficient light and the pole was visible from a distance of nearly 100 yards. The court rejected the plea of the plaintiff and held that the plaintiff could have avoided the accident by exercising due care. On a daytime, if a pole which is visible from 100 yards, if the plaintiff cannot see it and collides, then definitely it has to say that the plaintiff has also failed to exercise his due care. In this judgment, Lord Chief Justice Lenbro stated that a party is not to cast himself upon an obstruction which has been made by the fault of another and avail himself of it. He does not himself use common and ordinary caution to be in the right. One person in fault will not dispense with another not using ordinary care for himself. So, the court is saying that if you have, if the other person is fault, it will not dispense the plaintiff, it will not dispense, if only the defendant is his fault, it will not dispense the defendant when plaintiff has used ordinary care for himself. But where both has failed, then in that case there is no action in negligence that can be successful. Now, there are some case illustrations that I will discuss now to explain this rule. Now, again I will do a little bit of pictorial representation to explain. So, this is a circle and you have roads approaching from all the four sides and vehicles are also approaching. So, in this kind of a scenario, what you are required is to be much more watchful, much more careful, drive at a very less speed and try to avoid any kind of possible threat or risk. Now, from this side a bus was coming and it was trying to take this route. So, its pathway is this is its pathway. And the bus was driving at a relatively slow speed and there was not much enough witness or evidence to say that the bus was in excessive speed, but it was at a moderate speed. On the other hand, from this side a motorist was approaching. A motorcycle from this side Now there is evidence, and he was supposed to drive this way. This was the motorcyclist path and this was the bus's path. So the motorcycle was coming from this side and it was supposed to move out to this direction, and the bus was supposed to go from this direction. Now there was evidence of the fact people saw who were in the the circle, either as a shopkeeper or as a bystander, that the motorcycle exceeded its speed and wanted to cross before the bus actually came around this space. So this is the spot where the accident happened. This is the spot marked with X where the accident happened, and the motorcycle was trying to overspeed. Instead of reducing the speed, seeing the bus is turning, it tried to overspeed so that before the bus comes to the actual circular path, it can cross. And the bus was also trying to cross, so there was a collision between them and the motorcycle crashed, and the motorcycle, the motorist who was riding the motorcycle died in the accident. So in a case for action against the bus by the wife of the deceased, the question was that whether there was a negligence, second question was whether there is a contributory negligence, and whether the motorcyclist is entitled to any kind of compensation. And it was held by looking at the evidences that were available and presented by both parties that actually there was a negligence on the part of the motorcycle. So the trial court, which is the motor vehicles tribunal, actually decided that there is no compensation due to the motorist because the motorcycle was negligent and that was the cause of the accident, and the bus driver was not negligent. When the matter went to Supreme Court, the Supreme Court did not accept that. What Supreme Court said, that we accept the fact that there was definitely negligence on the part of the motorcyclist. However, we cannot rule out that the bus driver was not at all negligent, because it is usual that when in this kind of an intersecting point, the drivers of a bus will be usually looking out that whether there is anyone coming from any side or excessive caution will be taken. But there is no evidence presented by the driver or anyone that the bus driver was using with excessive caution or he was looking out. In his deposition, he did not mention that he was looking out. He said that I was trying to drive on my way and I did not saw the motorcycle. So what the court held, that therefore there is also some element of negligence on the part of the bus which cannot be completely ruled out. Maybe the and that is why it is a case of contributory negligence. So the defendant is also liable to some extent and the plaintiff is also liable to some extent. Now the question came that as per the rule of contributory negligence, when plaintiff is liable with the slightest of his contribution to the negligence, by negligence to the happening of the event, will rule him out of any kind of relief. Now the court said that, however, this rule has changed even in England. England, from where this rule of contributory negligence evolved in a 1945 Contributory Negligence Reforms Act, they have changed and they said that on the basis of apportionment of the risk or apportionment of the aspect of negligence that contributed by both parties, the compensation will be apportioned. So court said that either we can use that rule or we can, based on equity, good conscience, decide that what is the apportioned negligence compensation, because both has committed some kind of a contributing negligence in this. So the court therefore held that in this case the bus driver and the motorcyclist are both some way have to share the blame for the accident, and the defense of contributory negligence is applied here and apportion the blame and allow the claim of the appellant in proportion to the blame shared by the respondent for the accident, which was in this case 25% on the motorcyclist and 75% on the bus driver, and therefore the motorcyclist was entitled, the heirs of the motorcyclist was entitled to some 75% or 60% on the bus driver and 40% on the motorcycle, because the court held that the bus has a larger responsibility because it's a bigger vehicle. So on that basis, the apportionment, the claims were accordingly distributed. In another case, Andhra Pradesh State Road Corporation, here again same, a motorcycle is hit behind by speeding bus as a result of which the person driving the motorcycle died and another person on the motorcycle was injured. The deceased was driving the motorcycle at a very high speed. So the deceased was driving the motorcycle at a very high speed, and this was a case for a contributory negligence. So again the rule of contributory negligence was applied and the blame was apportioned, and accordingly 1/4 of the total compensation determined was reduced to the extent that 1/4 in this event was contributed due to the negligence of the deceased. The name of the case is Andhra Pradesh State Transport Corporation versus K. Hemlata. This was also decided by the Supreme Court in 2008. The earlier judgment was Srimati Vidya Devi versus Madhya Pradesh State Transport Road Corporation, which is 1974 Supreme Court decision. Now comes a very interesting question. Negligence of the plaintiff, which can be described as contributory negligence, must have a causal connection. So if the damage occurred and the negligence had no causal connection, then in that case contributory negligence cannot be ruled. The example of this is in this case Branch Manager New India versus Malinga. It's a Tamil Nadu High Court, Madras High Court judgment, wherein the court held the omission to wear a crash helmet by the motorcyclist involved in an accident would not amount to contributory negligence if the injury suffered by the motorcyclist is not on the head but on the hand. Rule is you have to wear a helmet, but if the motorcyclist is not wearing a helmet and the accident suffered caused him injury in the hand and the leg but not in the head, in that case contributory negligence cannot be claimed, that he would not have suffered the injury if he is wearing the helmet. So not wearing the helmet was contributed to the injury. That cannot be claimed because hand injury and wearing a helmet has no causal link. So causal link is an important factor that has to be determined when we are looking at contributory negligence. Now contributory negligence rule, whether it applies when it comes to children, so minors. As I said when we were discussing about capacity, that in torts no difference is made usually, but in criminal cases minors below 7 years is given complete exoneration from any liability by the theory of Dolly incapax. Now for example contributory negligence, and you can see contributory negligence is actually like a negligence. As defendant has committed negligence, the plaintiff has also committed negligence. So therefore it's an act, okay, or omission causing negligence. So negligence caused by act or omission. So whether a child can be held to have responsibility or liability for contributory negligence. Now in this case SM Railway versus Jamal in 1924, it's an old case in Madras High Court. It was held that child do not form a separate category either for deciding whether the defendant owed any duty to the child plaintiff or was guilty of negligence. A girl, in this case the fact was a girl of 7 years was knocked down by an engine while she was crossing the railway line after passing through a gatekeeper. It was held that the proximity cause of action was the negligence of the girl in not looking out for passing the engine when she was crossing the line, that she was capable of appreciating the danger and was old enough to have a sense of discrimination. She was guilty of contributory negligence. Now the court said that a 7-year girl who was knocked down by an engine on a railway line because she first passed the wicket gate. Wicket gate means when the gate is closed and then you crawl through. So you cross that in that way, or illegally cross, because when a railway crossing gate is closed, you are not supposed to cross. So you first committed a negligence there by crossing the gate. Still it can be ignored, but the point is that when after that you saw an engine, and a railway engine is not a small thing, it has noise, it has sound, it has visibility, and then you are 7-year-old, so matured enough to discriminate between the appreciable danger that can happen to you if you are trying to cross when a railway engine is in your close proximity. Now, if at that age you miss, then you cannot held the other party negligent, but you are negligent. So therefore, children are held negligent where the children can appreciate the danger and still they are negligent. So their negligence is not ruled out. Second category of cases where the question is whether negligence can be contributory negligence can be ruled is rescue cases by third person. Now in this case, plaintiff saw a boy standing on the track in an imminent danger from an approaching train which had failed to give the statutory signal. To rescue the boy, the deceased rushed upon the track immediately in front of the moving train, and in that act was killed. It was held that the deceased was not guilty of contributory negligence since a dangerous situation had been created and the deceased was justified in making the effort to save the boy. So as we saw, voluntary non-fit injury or consent defense does not apply in rescue cases. Similarly, contributory negligence rule also does not apply in rescue cases, because A, here the train was definitely negligent because it did not give the statutory signal. Second, it was a small boy whose life was threatened, and to save his life, which he did succeed, he gave his life. So in that case, instead of rewarding, if you put contributory negligence, it is punishing him for a good cause, and that cannot be the policy of law, and that cannot be just. So therefore, in rescue cases, in most of the cases, rule of contributory negligence is not allowed, as voluntary non-fit injury or consent defense does not apply. Similarly, contributory negligence also rule does not apply if it is a rescue for a third person. Now, before this apportionment rule came, either in England by the 1945 Act or later India by judicial decision, as the conventional rule of contributory negligence stand, when the plaintiff was negligent, he will lose his action in. If there is a successful plea that plaintiff also contributed to the happening of the event, although the defendant was negligent to some extent, then he will lose the plea of negligence. Now, of course, this was a slightly harsh rule, and that is why what the court devised subsequently is a judicial, counter to contributory negligence rule. Now that rule was called last opportunity rule, or who has the last opportunity. If we go back to our first slide example, now it is a 50 kilometer speed at which the defendant was driving his vehicle, and the speed limit was 20 to 30. It was a daytime. The plaintiff was at least 50 meters ahead and he started honking. All these are mentioned in the facts. And he understood that even after his honking for that distance, the plaintiff is not making any change of course. That means the plaintiff is not able to hear him. Now, of course, that is because of plaintiff's negligence, no doubt about it. But the question is that whether he had in 50-yard distance not the opportunity to avoid the accident. So when the accident happened in this spot, and when he had discovered the plaintiff was walking on the road, so there was this sufficient distance to cover. So there was a sufficient distance to cover. Which is approximately say 50 to 60 yards. And he was honking. But when he understood that after his honking also there was no change of course, couldn't he stop, pull, or slightly bypass the plaintiff and avoid the accident? So, who had the last opportunity at this juncture? Based on the evidence, the court will decide. If it is found that the last opportunity was in the hand of the defendant and he did not use that opportunity to avoid the accident, the defendant will be held liable. Now, this rule was developed in this case Davis versus Mann. It's an old case, 1882. In this case, the plaintiff left his donkey with two of its legs tied in a narrow street. The defendant was coming on his wagon at a very good speed. The wagon ran over the donkey and the donkey died. The court found the defendant liable as he had the last opportunity to avoid the accident by taking the ordinary care. So, it is not that the plaintiff is not negligent. When you leave a donkey on the middle of the narrow street with his legs tied, then of course you are negligent. However, the defendant was coming also in a very high speed, which is also negligent. It was a narrow street as mentioned in the facts, and he was driving at a high speed. That means he was driving a narrow speed beyond what is a normal reasonable speed. And then after seeing the donkey also, if he doesn't pull off or he doesn't slow down, then of course he had the opportunity which he did not able to take. So therefore, ordinary care, if he had exercised at that point of time, which he has to anyone because he is using the road, the accident could have been avoided, but he did not. So the last opportunity to avoid the accident was in the defendant. So therefore, the defendant will be held liable in this case. So the court observed, although the animal may have been wrongfully there, still the defendant was bound to go along the road at such a pace that would be likely to prevent mischief. Where this not so, a man may justify the driving over goods left on public highway, or even over a man lying asleep there, or purposefully running against a carriage going on the wrong side of the road. So no man can justify. Hence, therefore, as per the last opportunity rule, the defendant was held liable. And the last thing that I want to discuss is the apportionment, which I have already said. Earlier, the common law principle was that if there is a contributory negligence, the plaintiff will lose his action. But this was changed by virtue of the law reforms, Contributory Negligence Law Reforms Act of 1945 of England, and it was followed in most of the common law jurisdictions. In India, when in Vidya Devi case in Madhya Pradesh, which we discussed 74, when this matter was discussed, we found that there was no parallel legislation. So the court said that in such cases we have never been inhibited, as in the borrowing language of Justice Bhagavati, to apply the English rule. The court will determine based on what is necessary, and there are two options. One, the court could follow the English norms, or they could apply equity, justice and good conscience. Now, court here used the equity, justice and good conscience, which also said that apportion as per the responsibility in contributing to the event, and English law also said the same. So ultimately it is that English law also is best, but because it is a statute now, so you have to say it is a statutory provision. But India, we do not have a statute, so we still call it justified by equity, good conscience feature. So the apportionment of the damage happened. There are three cases that I have discussed: London Transport versus Lang versus London Transport Executive, which is a 1959 judgment after this Reforms Act came, where there was apportionment of the blame and 2/3 and 1/3 was the responsibility, and accordingly the compensation amount was determined. Similarly, in Vidya Devi, responsibility was apportioned in the proportion of 2/3 and 1/3, and the claimant were in the view allowed damages to the extent of 1/3 of what they would have got had the deceased negligence not contributed to his death. So because the motorcyclist was larger fault, because he was speeding, he was after seeing the bus also tried to still bypass it or overtake it in a narrow circular road. So therefore he had more contribution. So therefore 2/3 was his contribution, 1/3 was bus contribution. So accordingly he was allowed to get 1/3 of the claimed compensation amount. And lastly, in Municipal Corporation Greater Bombay versus Lakshman Iyer, it was found that the deceased negligence was 25% and then 75% of the compensation he was allowed to get. Similarly, Andhra also we saw it was 1/4 negligence. So therefore 75% he will be entitled to get of the reasonable compensation amount. Now we move to the next topic now, which is nuisance. Now nuisance is a separate tort. It is not same as negligence. What is nuisance? The word nuisance comes from a French or Latin word called nuire. Nuire means causing annoyance. So nuisance usually is related to whenever the act of the defendant causes annoyance, and the annoyance can be of various nature. There is no particular way by which sound annoyance, noise or sound annoyance, smell annoyance, foul smell annoyance, unnecessarily creating an environment which causes annoyance. So nuisance can be of various nature. So to do any what or cause of annoyance of lands, tenements or hereditaments. Lands, tenements means whatever control he has over his lands, his properties, which includes building structure, etc. And hereditaments is that building structure, etc. Garden, features, everything, all this. So nuisance is any kind of hurt or annoyance that is caused in connection to the plaintiff's lands, tenements or hereditaments and not amounting to a trespass. However, it should not be a trespass. Okay. Now difference between trespass and nuisance we will discuss in the subsequent lecture when we discuss trespass to land. But nuisance and trespass to land can at times overlap. But usually, as a just basic overview point I am telling you, when you throw a stone to somebody's land, it's trespass. When your overhanging branches of the tree of your garden enters into the land of your neighbor and shades his small bushes from getting sunlight, it's a nuisance. A trespass therefore has to be a positive act. We will discuss that in details in the next lecture when we discuss trespass to land. So any kind of hurt or cause of annoyance to land, tenements or hereditaments which is not amounting to trespass. Okay. Now nuisance can be of two kinds: public nuisance, private nuisance. What is public nuisance? Public nuisance is an act or an illegal omission which causes any common injury. This is important. Common injury, danger or annoyance to public or to people in general who dwell or occupy property in the vicinity or which must necessarily cause injury, obstruction, danger or annoyance to persons who may have occasion to use any public right. So what I do is that in a residential area, I establish in my house which is in that residential area, I start a rice mill. So I own a rice mill. Now earlier my operation of the rice mill was manual. So there was no much sound or no much noise or no much dust. But then in order to increase the production and looking at the possibilities of increasing my business, I replaced the manual system with an automatic system, a generator operated or a machine operated. The moment the rice mill was converted into a generator or a machine operated system, it started causing huge sound, noise, vibration, dust, smoke. Now that is a nuisance, and that nuisance is something that affects entire population of that area. That is a case of public nuisance. So it is an act or an illegal omission which causes any common injury, danger or annoyance to the public or people in general who dwell, occupy property in the vicinity, or which must necessarily cause injury, obstruction, danger or annoyance to persons who may have occasion to use that public right. So, one, to all the residents, and to any visitors. Similarly, if there is a highway which is used by a lot of people, okay, I leave a dump of waste. So I had a construction, there was a large bit of concrete waste and I went and dumped it on the highway. That's a nuisance. Now that may amount to trespass also, but usually it is treated as a nuisance, right? So dumping of things on public road or public annoyance, public convenience is a case of nuisance. Okay. Public nuisance can only be subject to one action. The restriction is that now everybody in this area or any visitor is being affected by this nuisance. But if everybody starts going to file a case against the same defendant, it is multiplicity of action, because ultimately there will be only one order that will be passed because there is only one defendant. So in case of public nuisance, because it is a nuisance of such nature that large bit of people are involved and large bit of people are annoyed, or large bit of people are hurt, or large bit of people are affected, or their properties are affected. So there can be many suits. Now that is not desirable. We all know that India already we have above 3 lakh case, 3 crore 60 lakh cases pending. We don't want a scenario where there is lot of cases unnecessarily coming to courts. So therefore, for public nuisance you can only have one action. So only one action is possible. So public nuisance does not create a civil cause of action for any person. Order have individual private right of action in respect of public nuisance. So there is generally no, so in public nuisance it does not create any civil right of cause of action for any person. Usually you have to go by using the criminal law procedure. Indian Penal Code allows for such kind of nuisance cases to be filing of complaint to the magistrate or filing of complaint to the police, and the police or the magistrate is supposed to take the action. So civil cause of action is generally barred when it comes to matters of public nuisance. However, a public nuisance can also give rise to private right of action in certain limited circumstances. What are those limited circumstances? First, he must show, the person who is bringing the action, that a particular injury to himself beyond that which is suffered by the rest of the public. So if the rice mill is situated here, and my house is adjacently on the same boundary wall, my house, and next say for 10 yards there is no construction, and after 10 yards there are some houses here and some houses here. Now this is a case of public nuisance because everybody is disturbed. But my annoyance, because I am in the common wall with him, is much more greater than any one of them, because A, there is a distance, B, they are not in the common wall. So when I can show, usually if the action has to be taken, it has to be a conjoint action, there is no civil action. But if I show that in particular injury to myself beyond what is suffered by the rest of the public, then I have a cause of action under private nuisance, public nuisance. Private cause of action under civil case to file against the defendant under for a public nuisance. Second, such injury must be direct and not a mere consequential injury. So, I am a direct affected party. It should not be a mere consequential, something has happened, so surrounding something, it should not be that. It must be a direct, and private and particular injury is not sufficiently direct to give a cause of action. Right. So, it is direct and not merely a consequential injury, and private and particular injury is not sufficiently direct to give the cause of action. And third, the injury must be shown to be substantial character. The injury must be of substantial character. So, there are three conditions where usually the rule that civil cause of action is not allowed in public nuisance will be overlooked. Is one, when there is a particular injury to me which is more than anyone else. Second, the injury is direct, and third, it is of substantial character. So, one is himself beyond that what most or rest of the public is suffering. So, from here to here. So, this is point 1. Second, must be direct, and third, substantial character. Then a private action may lie in a public nuisance case. Next, moving to private nuisance. So, this is public nuisance. Now, moving to private nuisance. Private nuisance is using or authorizing to use one's property or of anything under one's control so that injuriously affect an owner or occupier of property by physically injuring his property or affecting its enjoyment by interfering materially with his health, comfort or convenience. Public nuisance is where a large number of people are affected. Okay. Private nuisance is, I have this house and there is a house which is of Mr. B. A is my house and B is Mr. B's house. Okay. So, there is a pathway between us. And what I do is that I drop my waste of the house, whatever waste is generated in my house, I drop on this road at the middle of the night every day. And the waste contains remains of whatever food items or other household used items, and they attract a lot of insects like rats, cockroaches to come and feed on that, cats, and a filthy smell will also come out. So, this is a complete case where I am annoyed, and without other than me, B is annoyed, and other than B largely nobody else is affected. So, this is a case of private nuisance. Because private nuisance is using or authorizing to use one's property or of anything under one's control so as to injuriously affect the owner or occupier of property, another property by physically injuring his property or affecting his enjoyment of interfering the material health, comfort or convenience. So, in private nuisance therefore, three things has to be there. An unlawful act has to be there. So, my act of depositing the garbage on this road. A damage has to be there. Okay. So, the fields, this is causing a damage because all these causes hygiene issues, then all these causes health questions, and the damage must be substantial and not merely trifling, fleeting or evanescent. So there has to be act, there has to be a damage, and the damage has to be of substantial nature. Then it is a case of private nuisance. Who can sue for nuisance? An actual occupier of a premise can alone bring an action for nuisance. So in this case, only B can bring a suit for nuisance. So an actual occupier. Now if the B is a tenant and the house belongs to C, but B is a tenant, lawful tenant. So when B brings the action, I go and oppose that who is he? He is a tenant. The owner has not brought. So the answer is, it's not the owner, it's the actual occupier of the premise. So B is the actual occupier of the premise now, so B has a right to bring the suit. Second, person who has no interest in the property, no right of occupation in the proper sense of the term, cannot maintain an action for nuisance. So it has to be a person who has an interest in the property or has a right of occupation in the proper sense of the term. Then only he can maintain. So who has a right, who has a interest in the property or has a right of occupation? Actual occupier in case the house is closed, but I have maintained the house. So my house is here and I have maintained the house properly. I have kept it under my control by using lock and key. I come once in every month to see its maintenance. I pay its all bills like corporation, taxes, electricity charge, water charge. So the house is in my control. Now someone comes, my neighbor who is adjacent, seeing that the house is closed and this is my boundary, say this is my boundary wall. And this is his boundary wall, and there is a space between us. There is a space. Now he starts depositing his regular daily waste materials in that place because he thinks that I am not staying there, so who is going to complain? Now I can say yes, I can file a suit. Now he may say how? I will say interest in the property and right of occupation. Who is liable? Who creates or continues nuisance or authorizes or suffers the creation of nuisance? Who lets sell property with nuisance? Who neglects some duty and allows to arise? The last thing is, what are the remedies that are possible in case of nuisance? Of course, the first remedy that is available is damages, but then you have to show that there is a substantial nuisance and what is the loss that has occurred or incurred because of that. But if you need a temporary immediate action, sometimes it can be permanent also, you can file for an injunction. And lastly, what is called abatement. Abatement is more of a removal of nuisance by the party injured without recourse to legal proceeding. So it can be peaceably, without damage to the life or limb of anyone, and enter into others' land to abate the nuisance, and no more damage may be done than is necessary, or proportionality. So abatement is removal of nuisance where you can do it peacefully, it is without any legal recourse. First two are with legal recourse, so judicial remedy. abatement is a non-judicial remedy. So, in order to do abatement, you may have to enter the premise of the other person. You should enter it peacefully, without danger to anybody's life and limb. If necessary, enter, but don't do a harm to that property more than what is necessary. Illustration: if my overhanging branches of my neighbor comes and crosses my land and shades my small bushes, I can enter his property to cut those branches, but I should not do more than what is allowed. Only those branches which are, I cannot cut the entire tree. The moment I do that, it is a trespass. Then I commit trespass. So, therefore, this non-judicial remedy should be used with always care. It is a matter of self-help. So, with this I end this lecture. I hope you are clear about these two important aspects of law of tort: contributory negligence and nuisance. In the next lecture, we will discuss trespass. First, we will discuss trespass to person, then we will discuss trespass to property. Okay? Thank you very much for being with me, and hope to see you again in my next lecture. Thank you.